Hello and welcome. I am Professor Raman and this is our 8th module about the extraordinary chambers in the courts of Cambodia and the special court for Sierra Leone. The learning outcomes in this module are for you to understand the history of the atrocities committed in Cambodia by the outfit known as the Khmer Rouge and in Sierra Leone by the parties to the civil war. And finally, to understand the establishment of extraordinary chambers in the courts of Cambodia, the so-called ECCC, and the Special Court for Sierra Leone, the SCSL. Let us first think about what is the jurisdiction of the extraordinary chambers in the courts of Cambodia and the Special Court for Sierra Leone. Let us also understand what is the jurisprudence developed by these two courts, the ECCC and the SCSL. By the end of this module, you should know the stories of the atrocities in Cambodia and Sierra Leone. We will begin with Cambodia. The introduction to understanding Cambodia and the history of the conflict begins with the Khmer Rouge regime and the establishment of the ECCC. The Khmer Rouge, also known as the Communist Party of Kampuchea, ruled Cambodia from 1975 to 1979. It came into power after the Cambodian Civil War between the Khmer Republic with the assistance of South Vietnam and the United States on the one side and the Khmer Rouge and North Vietnam on the other. This outfit, that is the Khmer Rouge, the Red Khmers, so to speak, was led by one Pol Pot, who was the General Secretary of the Communist Party of Kampuchea. He was accused of what later came to be known as the Cambodian genocide. Under the instructions received from Pol Pot and the infamous Group of Four, approximately 1.5 to 3 million people, a fourth of the population of Cambodia, were decimated. The party, the Communist Party, aimed at following the ideology of the Soviet Union in creating a socialist agricultural society or a pure Khmer society. In this, you might find traces of the Aryan race theory propagated in Germany. The Khmer Rouge attempted to turn Cambodia into a classless society. It depopulated cities and forced the urban population into agricultural activities. The entire population was forced to become farmers in labor camps, as Pol Pot wanted Cambodia to be a self-sufficient agrarian economy. The Khmer regime ordered tortures, mass floggings and execution. They suspended the right to habeas corpus, the elimination of health care and education, and followed a regime of persecution based on a bias against religious minorities. Farmers were expected to produce 3 tons of rice per hectare, 3 times the actual yield of the land. The lack of agricultural knowledge by the former city dwellers made mass killings and floggings common. Rural dwellers were often too frightened to assist the urban population, thus making famines inevitable. The Red Khmer executed hundreds of thousands of innocent civilians. Currency was abolished, books were burned down, and the Khmer Rouge shut down all hospitals and schools. Teachers, professionals, and the entire intellectual population of Cambodia were executed on a mass scale to make the agriculturally communist state of Kampuchea. All economic activity was halted because it was antithetic to the Khmer ideology. Banks, industries, and service companies were closed in the planned relocation to the countryside. Existing banks were raided and all currency and bank records destroyed by burning. The Khmer Rouge overworked and starved the frightened population, and those who dared to resist were brought down brutally. Under the Khmer Rouge, like many other communist systems, religion was banned, and all those who preached or practiced any form of religion were immediately executed or brutally tortured. After about 12 years of the beginning of the rise of Pol Pot, on April 18, 1978, Pol Pot ordered an invasion on Vietnam, a close ally of the domestic opponents in the Khmer regime. The Vietnamese army immediately retaliated, invaded Cambodia and captured Phnom Penh on 7th January 1979. This led to the establishment of the new People's Republic of Kampuchea that gradually recovered demographically and economically from the Khmer Rouge regime. The invasion and recapture of Phnom Penh was with the assistance of the United States. The United States had long opposed communism in many forms, in any form, and this was part of the United States' ongoing agenda to uproot and destroy communism. The period of failed justice and reconciliation was born after resentment from the period 1979 to 1997 had festered in Cambodia. Various attempts were made to domestically try Khmer Rouge officials, but in vain. The country had little to no international participation and presence, which made things worse, and the high-level officials went unpunished. However, the new Cambodian government formed the People's Revolutionary Tribunal in 1979 that for the first time tried Pol Pot, former Democratic Kampuchea Prime Minister, and the former Deputy Prime Minister Ieng Sari in absentia. This tribunal convicted them of genocide. The international community, however, failed to recognize this tribunal as it did not meet international fair trial standards. The tribunal, interestingly, lasted only 5 days. It was the first tribunal to try individuals for act done under the 1948 Genocide Conventions. Most of the international community termed the trial as a sham trial because of the ideological differences during the Cold War era and the period in which the tribunal was sought to be set up. The trials were perceived to be a post facto justification of the invasion of Vietnam into Cambodia. Cambodia had become a battleground for the superpowers, pitting local, regional and national rivals against each other and engendering support from international allies such as the United States. In 1999, the United Nations advised Cambodia to create an ad hoc criminal tribunal, but this advice was rejected by the royal government of Cambodia. In 2003, an agreement was negotiated between the United Nations and the royal government of Cambodia that assistance would be granted along with international participation if the royal government of Cambodia were to agree to the creation of an extraordinary chambers in the existing courts of Cambodia, a project which began on July 2007. The ECCC is a completely new form of a mixed tribunal formed by an agreement that allows for the panel of judges and prosecutors to be appointed by either the Cambodian government or the United Nations. This became the first example of this kind of hybrid cooperation between national and international. The ECCC is designed to provide fair trials in conformity with international standards of justice, but applying national law. The court's jurisdiction extends to international as well as municipal laws. It can give a maximum punishment of life in prison because Cambodian criminal law does not permit the death penalty. Any accused can be represented by a Cambodian or an international defense counsel of their choice, and the presumption is that they are innocent until proven guilty in conformity with most systems of common law. the proceedings are initiated by the co-prosecutors, who then allow the co-investigating judges to carry out the actual investigation. They either indict a person and send him accordingly to the trial, or they dismiss the proceedings. The ECCC is the first international criminal tribunal of this hybrid sort to allow the accused to participate in the trial and have the same rights as any civil party. The first trial of the court was of so-called Brother Number 1, Kaing Gueng Ev, former chairman of Phnom Penh Security Prison S21, the infamous Tuol Sleng. He was convicted for crimes against humanity. The ECCC tried and sentenced him to life imprisonment, along with 4 other individuals. Former Deputy Secretary of the Communist Party, Nuon Chia, and former Head of State, Khieu Samphan, are currently under trial at the ECCC. Ieng Tirit and Ieng Sari are also under trial. The ECCC was formed and has the jurisdiction to try only a specific mandate of individuals. It will cease to operate once its mandate is completed. How does one problematize the process of arriving at justice through a hybrid court? A different approach could have been to advocate universal jurisdiction for these top leaders, which could be exercised by any state which claims such jurisdiction, an approach which did not find, at the stage where it would have been a relevant solution, too many takers. A different approach would be to invoke the jurisdiction of a specialized institution such as the ICC, which under its complementarity regime might ensure that an end may be put to the culture of impunity. However, there remained serious obstacles to this course in terms of the powers that the ICC itself is bound by, such as jurisdiction and temporal jurisdiction, that is the time of occurrence of the crime, both of which in many situations it could not have met. This was compounded by the political problems in bringing certain cases such as the Khmer Rouge trials out of the Cambodian context into an international city such as The Hague, for example, and the problems of definition, admission, jurisdiction, resources, most importantly evidence. This made the creation of the special tribunal as it now exists the only workable way to achieve some modicum of justice for victims and witnesses of these atrocities. The biggest criticism against the tribunal is how much after the genocide it was formed. They say justice delayed is justice denied. This tribunal, following the established chain of command responsibility doctrine, can only prosecute top-level leaders who are alive and traceable. Unfortunately, this allows most of the topmost leadership because they are dead. It is difficult for the ECCC to handle administratively and outside the mandate of the top-level prosecutions the limited number of accused that are still alive. Most of them have severe mental degeneration and are very old. The limited way in which the chambers operates is less than satisfactory to many in the international community. Like other tribunals, lower-level perpetrators will never be brought to court. A judge from the ECCC was once quoted as saying in this context, open quote, "You may know who killed your father or sister and still see that person walking around. They will not be prosecuted. That is a limitation of the ECCC. But it's better than nothing." End quote. In Cambodia, it is easy to imagine that the trials might not have convinced too many in Cambodia that justice was indeed being done, especially since many members of the Red Khmer actually see people who were torturers under the Khmer Rouge regime walk around freely, unpunished. Through its trials, the tribunal is trying to restore a sense of justice to Cambodia and thus advance the rule of law to the so-called lost generation. The international community, headed by the United Nations, recognizes this possibility when it recommended the creation of this special tribunal under Resolution 57 of 228, adopted by the Secretary General along with the General Assembly in December 2002. The resolution emphasized that, open quote, the accountability of individual perpetrators of grave human rights violations is a key factor in ensuring a fair and equitable justice system within a state. Close quote. While the beginning of the first trial and detention of the rest of the defendants are good first steps, the judges and administrators now have the reins and must steer the chambers down a sure and steady road. If they succeed, the trials may serve as a model for future hybrid innovations that draw upon proven and established international justice mechanisms in order to improve existing domestic systems. It demonstrates the power of international law to effect domestic reform. Moreover, the Chambers model confirms the importance of designing ad hoc tribunals that are appropriate to the context in which they must operate. Before proceeding with that, however, the gaps and ambiguities in the internal rules of the court relating to certain unregulated areas, such as how exactly does one distribute responsibilities between international and national staff? How does one create a fair and transparent process of recruitment? How to evolve a set standard of ethics, etc. These must be amended in order for the proceedings to run smoothly and, to be more importantly, to be considered legitimate by the international community. Uncertainty over the distribution of responsibilities between international and domestic actors leads to a larger question about who is the audience for this tribunal. Who is this court for? Efforts to fit the chambers into the domestic legal culture may require stepping outside the bounds of traditional transnational legal norms. This may meet the demands of the Cambodian people, but will it suit the international community that holds the ECCC's purse strings? These are the open questions that I leave you with as we move on to the second tribunal in this module, the Sierra Leone Civil War and the Special Court for Sierra Leone. Let us first consider the history of the conflict. Sierra Leone is a former British colony that was ruled by successive corrupt governments until the Civil War broke out in 1991. The war that started as a rebellion by the Sierra Leonean army was welcomed and seen as an animation of progressive reform agenda. However, this disillusion quickly disappeared as the conflict degenerated into a campaign of brutality and atrocity, whose principal victims were the rural peasants. This 11-year-old war took nearly 50,000 lives. In 1997, the Sierra Leone army organized a coup d'etat to overthrow the existing government. The army advanced on the capital, Freetown, and destroyed much of the city and overthrew the Joseph Momo government. From this step, the conflict escalated and became a full-blown international armed conflict. The government of Sierra Leone requested the United Nations to help in the establishment of an international tribunal to deal with the war crimes in Sierra Leone. However, the Security Council had recently been swayed from using its Chapter 7 powers to establish additional ad hoc judicial institutions. You see, by 1997, 2 courts were already in existence. Cambodia had started. Nevertheless, on 14th August 2000, the Council requested the Secretary General to proceed with the negotiation of an agreement with the government of Sierra Leone to establish a new independent special court. This new tribunal was not to be created by resolution of the Security Council, acting under Chapter 7, but pursuant to a bilateral treaty. After the negotiations, in January 2002, this bilateral agreement between the government of Sierra Leone and the United Nations was signed. This gave birth to the Special Court for Sierra Leone, the so-called SCSL. What are the features and the possibilities of jurisdiction of the SCSL. The Special Court for Sierra Leone is very similar to the hybrid tribunals like the ECCC that we have just studied, but the SCSL can be more accurately classified as an ad hoc tribunal because it is a creation of international law and not a cooperation between international and domestic law. This is a purely international law driven court. It did not derive its powers from a resolution of the Security Council, as we have just explained. Its existence is derived from general and specific powers in the UN Charter. It derives its general powers from Article 1 and specific powers from Articles 39 and 41 of Chapter 7 of the UN Charter. The Charter therefore helped establish the tribunal through agreement like it did with Resolution 1315. Since the Special Court for Sierra Leone is created by a treaty, it leads to a negative effect on its powers. The Special Court cannot issue directives to states. Its primary jurisdiction as well applies only to the courts of Sierra Leone. Even the exercise of its jurisdiction over domestic courts is only viable due to the Special Court Act. This is an internal legislation that was passed in Sierra Leone to bring into effect the treaty that was signed with the United Nations. Without that legislation, the court would not be powerful. But the problem with the legislation came to light in the case of Charles Taylor, the then president of Liberia, who surrendered to appear before the court and was to be tried while he was still the sitting head of state of Liberia. The defense that Taylor took was that the existence of the court was based upon an agreement between the government of Sierra Leone and the United Nations. Its jurisdiction was therefore constricted only to that of the government of Sierra Leone within its territorial bounds. The second defense that Charles Taylor took was that the Special Court of Sierra Leone violated the Constitution of Sierra Leone, as Section 120, Clause 1 of the Sierra Leonean Constitution reads, and I quote, "The judicial powers of Sierra Leone shall be vested in the judiciary, of which the Chief Justice of Sierra Leone shall be the head." To these defenses, the appeals chamber of the SCSL responded that it was established to fulfill an international mandate and is part of the machinery of international criminal justice. Secondly, to the defense that the court is not part of the judiciary, the court said that yes, it is not part of the judiciary of Sierra Leone, but the explanation under Article 11D of the Special Court Agreement gave the court the capacity to enter into agreements with another state, something that national courts of Sierra Leone cannot do. Using these, the court responded to Charles Taylor's defense. The three-member bench of the Sierra Leone Appeals Chamber concluded that by nature, the SCSL was an international criminal tribunal broadly similar to the ICC, the ICTR and the ICTY, including in relation to the provisions confirming the absence of entitlement of any person to claims of immunity. There is no reason to conclude that the Special Court should be treated as anything other than an international tribunal or court, with all that that implies for the question of immunity for a sitting head of state like Charles Taylor. The SCSL therefore rejected this challenge to jurisdiction by Charles Taylor, who had been president of the neighboring state of Liberia when the indictment was served upon him. Interestingly, the Charles Taylor case became the flagship case of the Sierra Leone court. To conclude, we have learned the following in this lecture. We have learned about the atrocities committed in Cambodia by the Khmer Rouge and in Sierra Leone by the parties to the civil war. We have learned about the process of establishing the extraordinary chambers in the courts of Cambodia and the Special Court for Sierra Leone. We have spoken about the jurisdictional reach of the extraordinary chambers in the courts of Cambodia and the special court for Sierra Leone. We have also spoken about the jurisprudence developed by the ECCC and the SCSL, that is the cases of Kaik Gueng Ev, Ieng Tirit, Ieng Sari, Nuon Chia in Cambodia, and Charles Taylor in Sierra Leone. Thank you.